Right, now we're going to have Mike Salthouse from the North of England P&I Club. Mike is going to take up from where Mr. Dalle Vedove left it, basically on armed guards. And he will give us a small presentation, a short presentation, we hope, on the P&I perspective for that. Mike.
Thank you very much. Can you see that? The slides? Can we get the slides up? Can we get the slide up? Good, excellent. Right, now, first of all, thank you very much, Francisco, for organising this quite splendid seminar. I'm delighted to be able to come here and talk to you today about piracy. First of all, the bad news. In the first 9 months of this year, piracy attacks were up. 199 reported piracy attacks compared to 126 in the same period last year. The good news is the success rate is down. Last year, 28% of all attacks were successful. This year, I believe the figure is down to about 12%. And I think few of you would dispute that one of the reasons why the pirates are being less successful is the heavier use of armed guards during the 2011 year. Now, of course, piracy has been around for many, many years. This bunch of scallywags were operating in the Indian Ocean way back in the 17th and 18th century. What I find most interesting is that the reasons why they were able to operate are exactly the same today as they were back 200, 300 years ago. To remove piracy, you need to do two things. First of all, you need to find the pirates, and then secondly, you need to put them away, either by a cannonball or because you found some effective way of prosecuting them and imprisoning them. And this is where we're all going wrong. William Kidd, who appears third on that list, when he was caught, was hung, and then he was put in a gibbet for 3 years. A gibbet is a steel cage, and his body was hung out over Millwall Dock on the Thames as a warning to anybody else who felt the need to follow him into piracy. These days we have a very different approach, and I think we probably apply first world standards to a medieval or even third world problem. So, for example, if you take some ships where pirates have been caught, if you look at the Almizan, which was documented by the United Nations, there was an instance there where the Spanish Navy came across some pirates who had clearly been involved in an attack on a vessel. Their ship was riddled with bullet holes. There was one dead pirate on board the vessel, and when questioned, they admitted they just attacked a merchant ship, the Almizan, and that 2 of their number had in fact died in that attack. When the Navarra, the Spanish Navy frigate, approached the Almizan, they were told, oh no, nothing's happened here, absolutely not, there's no armed guards on board this ship, we fired flares, that was it. And so what could the Navy do in those circumstances? Answer was very little. Those pirates were patched up at taxpayers' expense, they were treated for their wounds, and then they were set free. There was no evidence to prosecute them. Or take, for example, the comment, I think, of U4NAV earlier this, probably last week, where they compared catching a skiff armed with ladders, RPGs and AK-47s to a policeman just on open water, to a policeman driving alongside a Ferrari that's doing just underneath the legal speed limit. Both the Ferrari driver and the skiff have the potential to break the law, but as yet they haven't done so. And applying our very proper first world standards to this medieval problem, we let the pirates go. So, what is the conclusion of that? Well, the answer really is that prevention is better than cure. The focus of states, navies and industry has been on preventing the pirates gaining access to the ship rather than to locking them up, perhaps. We had in 28 the formation of U4NAV, Operation Atalanta. The transit corridor was introduced at about the same time. Vessel hardening, we have an excellent guide in the form of best management practices, now in its 4th version. And certainly I think the adherence to BMP4 is probably better this last year than it has been by ship owners than it has been in the past. But perhaps the naval gentleman would like to comment on that later. But also, perhaps inevitably, we've had a trend towards armed security, either vessel protection detachments of using the armed forces of a sovereign state, or because they tend only to be available to ships flying the flag of that nation, to the use of private security contractors. And so, what do we think as insurers about the use of private security contractors? Well, our position is pretty well recorded. In the outset, or at the outset, we had some concerns. We didn't think that ships and weapons mixed particularly well. the industry is new. There are certainly some very good private security companies out there, but there are also some who have very little understanding of the legal and operational framework in which you as ship owners have to operate. In terms of what the clubs now say about it, you can derive our views from three sources. BMP4, of which we're a sponsor, says these days as follows: the use or not of armed private maritime security contractors on board merchant vessels is a matter for the individual ship operator to decide, following their own voyage risk assessment. Our individual club newsletters and briefings say very much the same. The use or not of private security contractors is a matter for the individual ship operator to decide. And indeed, the FAQs, which are published by the international group, these are frequently asked questions concerning the matter of piracy, say very much the same. They're even more positive, in fact. There has been a shift from a general position or general opposition to more of neutrality, particularly in high-risk cases, positive support for the use of armed guards. So the clubs, along with industry, ICS I think is a similar view, have moved from tacit opposition to a position of neutrality. Our involvement with the armed guards really comes out of the contract reviews. If you look at the IGFAQs, which is a very comprehensive document, sets out very clearly what our position is in relation to all matters in respect of piracy, you will see that we always ask to be provided with a copy of the contract that the armed security guard is using before it is signed. The reason? Well, there's a couple of contracts up there. The one on the left was a one-page document. Half of it is written in Arabic, and that was setting out the terms for the use of a set of armed security contractors for a 12-month period. The contract on the right, rather better, 20 pages or so, setting out the liability provisions, jurisdiction, insurance, backup of the security contractor, and also dealing with the rules of engagement that they would use in the event of an attack. So there are some very poor contracts out there, some very poor guards out there, and there are some companies which probably have a better understanding as to what is required. What do we look at? Well, the purpose of our contractual review is simply to ascertain whether or not the ship owner is about to contract on terms that will put him outside the scope of cover. Nothing more, nothing less. We don't, by our contract reviews, approve the guards. We only approve that particular contract for that particular use, one voyage use. The general advice we give tends to go over the obvious points that you would expect us to pick up. We advise, for example, that you need to get flag state approval for the carriage of armed guards, their weapons and ammunition, that you should make sure that the presence of those guards doesn't compromise SOLAS, and that if you are going to modify your ship to put in place fixtures to mount machine guns or whatever it might be, then you might need to get the approval of class. The contractual advice is more specific. We're looking particularly for indemnity provisions, which we can't ensure or recover under the pooling agreement. We would only allow indemnity provisions under which an owner assumes a responsibility that wouldn't otherwise be his if they form part of a knock-for-knock or reciprocal set of indemnity terms. And we would also expect to see any limit of liability to be equal on both sides. Rules of engagement, we also cast our eye over those. They don't tend to be a cover issue, and we certainly wouldn't hold ourselves out as experts. But what we're very keen to avoid is any suggestion that the master is the party referred to as a point of contact when the shooting starts. We don't want to see the master being asked to sanction the use of force. That will put him in the frame if force is used unlawfully, and we all know that when things go wrong in shipping, it's very often the master and the ship owner which are asked to carry the can. A few words about vetting and accreditation. We have benefited enormously recently from the IMO circular MSC1 Circ 1405 Revision 1, which provides guidelines to ship owners when they're looking to select armed guards. It contains some very sensible advice and areas which ship owners should look at if they're going down that particular route. However, it is up to them to apply those guidelines in a manner to ascertain whether the guard company comes up to scratch or not. That is vetting. They can either do it themselves, in the same way that oil majors will vet ship owners to see whether their ships are suitable for chartering, or they can outsource it. And there's various people who probably do that for you. Grey Page is one based in the United Kingdom. Accreditation is something rather different. Accreditation is where the industry itself sets the standard to which those members of the industry seek to attain. There's an organisation, SAMI, you may have heard of them, the Security Association for the Maritime Industry, which is working hard to set up some form of accreditation. And as far as the clubs go, we wish them success. We very much hope that they do set up a standard which will come to be seen as a badge of excellence, so that the ship owner, when he's doing his vetting, when he's selecting his armed guards, can say, that's a SAMI member, that means, or I can rely on the fact that that means A, B and C. But vetting and accreditation, injury time, almost finished. Vetting and accreditation are two quite separate things. So conclusion, it's rather pessimistic. I would only say that it is probably only going to get worse. We, the clubs, and this is the club perspective, are not really caught up in the financial consequences of piracy. We tend not to be asked to pay ransoms because property underwriters and K&R pick up that particular burden. We do, though, see that this is the biggest single issue in shipping at present, and we are there to support our members, and if that means using armed guards, then we'll try and find ways to assist them in making the choices that entails. Thank you very much.